on the recent Supreme Court decision, which actually confirmed everything we did in C5. The minimum mandatory penalty we struck down, the court struck down as unconstitutional. Work is underway to develop legislative and non-legislative options. In the coming days, I will be reaching out to justice and public safety counterparts to convene an urgent FPT meeting to continue our important work on bail.
Questions and comments? The honourable member for Brantford-Brant.
Thank you, Mr. Speaker. I encourage the Attorney General and Minister of Justice to reread that Supreme Court of Canada decision that was released last week, because I'm looking at it right now. For the record, it's Regina versus Hillback, and in a 7-2 decision, that particular court indicated that the 4- and 5-year mandatory minimums for robbery with a firearm and robbery with a prohibited firearm were not grossly disproportionate and did not constitute cruel and unusual punishment and were charter compliant. But the court opined that given the results of Bill C-5, that the issue was now moot. So I encourage the Justice Minister to reread that decision. My point, though, however, is that I heard him indicate earlier this week that he was open to suggestions. He was looking for some ideas. He has literally heard from the provinces, from police chief, from premiers, from interested parties for close to 11 months now, crying out for bail reform. He's indicating that talks are in the works. Be specific, Minister. What are you doing?
The Honourable Minister.
Thank you, Mr. Speaker. I thank the honourable member for his question. I would recommend to him that he reread not only the Supreme Court decision, but also Bill C-5. I realize the problem was the inflammation of rhetoric during the debate on C-5. We did not remove all the minimum mandatory penalties with respect to those gun offences. We only did it in a very narrow band, and it mirrored exactly what the Supreme Court did, Mr. Speaker. Mr. Speaker, we have been on this question for a long time, since, at the very least, the federal provincial territorial meeting of last October. As I mentioned in my speech, Bill C-75 basically reframed the Supreme Court of Canada jurisprudence that had evolved over previous years. It added reverse onuses with respect to intimate partner violence. There are some reverse onuses that already exist. We're working with the provinces to find other ways to improve the law while remaining charter compliant. These discussions have been going on, particularly at a technical level with our experts. We're going to continue to do this. Mr. Speaker, we have a responsibility to do this. We've exercised that responsibility. We don't wait until inflammatory rhetoric drives us. We've been doing this for a long time in a prudent way in collaboration with our partners.